Good
Advocate
afternoon.
Gaurav Sharma ji,
Yeah.
CS Ashish Korea, Central Council Member ICSI, and delegate present here. Good afternoon to all of you. Now I request CS Ashish Korea sir, Central Council Member ICSI, to deliver the welcome address. Please, sir.
Thank you, Rajesh sir. Good afternoon, everyone. My warm welcome to all of you. Friends, keeping up with the commitment of the ICSI to provide continuous in-depth theoretical and practical knowledge to its members, the Institute has taken initiatives in the role area of ADR through web series on mediation. This webinar series will help the company secretaries prospecting towards relating fields to become multidisciplinary professionals with inclusion of the new role as mediation professionals. The third webinar of this series shall focus on process and stages of mediation. For this, we are having Mr. Gaurav Sharma ji with us. We welcome you, sir. Friends, Mr. Gaurav Sharma is graduate from OP Jindal Global University pursuing the BLLB honors program. During this period, Mr. Sharma was privileged to attend an exchange program on international law and global governance at the University of Oxford. Mr. Sharma thereafter pursued Master of Law in International Trade and Commercial Law at the University of Durham, United Kingdom. He happens to be the youngest recipient of the prestigious fellowship conferred by the Chartered Institute of Arbitrators, United Kingdom. Mr. Sharma currently appears as counsel before various courts of laws in Mumbai, has also appears in domestic and international arbitrator proceedings. Mr. Sharma has also been engaged as an arbitrator. Friends, Mr. Sharma is a research scholar with the University of Mumbai and is pursuing his PhD in law. Mr. Sharma has also been invited as an adjunct faculty with the Mumbai National Law University, Mumbai, at Powai, and teaches the LLM batches on the area of alternate dispute resolution. With this, once again, I welcome you, sir. And now I request you to please deliver the session.
Thank you so much for that warm welcome, Mr. Karodia. It is always a pleasure to be interacting with such luminaries from your prestigious institute. And this happens to be one of those intersections wherein a lawyer like myself could have a dialogue with, respected, reputed professionals from the Institute of Chartered Secretary. And today's discussion, as Mr. Garudia was kind enough to bring about, is on the stages of mediation. Now, just before we start with the stages of mediation, and I could possibly take you all through the nuanced approaches of how a mediator has to conduct themselves and what exactly are the intricate stages wherein a mediation process requires, we should first understand what exactly is mediation. So I'll just touch upon it a bit, and then we can go and appreciate the stages of mediation. Now, today's discussion, I would really hope that the takeaway from today's discussion would be that you all could come out as resolutionaries. Now, what I mean from resolutionaries is have the inclination and mindset to resolve disputes out of court as an alternate dispute resolution. I would like to tell you that as a lawyer in law school, I have always been trained to challenge. You challenge constitutional validities, you challenge positions of law, you challenge courts with, distinguishing judgments and interpreting law in a particular manner. Whereas the ICSI candidates, professionals such as ourselves, have been trained to comply. There's a lot of compliance related work that is integral to your working and functioning. Now, this happens to be a very interesting intersection whereby professionals such as yourself and me could possibly try to resolve disputes. And there is a huge difference between the word resolving disputes and adjudicating disputes. What we do in courts by appearing for companies, clients, parties, presenting the case before a particular judge. He is the judge, the respected judge, the honorable judge, and the honorable court is tasked to adjudicate the dispute. So decide the dispute within the four corners of law based on precedents, that is earlier judgments that have been delivered by superior courts such as the Supreme Court or a High Court. So based on that, the court's responsibility is to adjudicate a claim. It is not to resolve a dispute, it is to adjudicate a claim within the four corners of law. But to resolve a dispute means that you are not bound by any procedure or any law, not restricted with jurisdiction, to try to resolve the dispute that is pending or has originated or germinated between two parties. Now, for a dispute, we need to have two parties. It is very difficult to have a dispute with yourself. Now, only and only when there is this germination of a difference or a dispute, would you then require to have a conflict check as to how do you wish to resolve this dispute? Do you want to leave it to a court of law, or do you have the power, skill set, knowledge, know-how to resolve this dispute out of court? Right? So which is why we have something called as ADR, that is alternate dispute resolution. In alternate dispute resolution, we have our resolution mechanisms. The most underrated, unfortunately, is negotiation. Negotiation, from its very nomenclature, implies that two representatives of two companies or two parties or individuals, as the case may be, have communicated amongst themselves as to what is the difference or dispute that has arisen. Once they identify the problem, they exchange manners of solving the problem, resolving the problem. And once they can find some kind of common ground, inter se amongst themselves, they have understood that this is the manner in which we would like to resolve the issue. For this, there is no requirement of approaching a court of law. There is no requirement for you to be engaging the legal services of any lawyer. All you need to know is have the practical knowledge of understanding what is the dispute, how it has arisen, and what are the practical solutions to it. Now, negotiation is a very crucial aspect and is also part and parcel of conciliation, mediation. As we know, the alternate dispute resolution mechanisms would be: first is your negotiation, then is conciliation, that is defined in the Arbitration and Conciliation Act of 1996. You then have arbitration, which basically is a quasi-judicial manner of dispute resolution. So it is at a little variance from mediation and conciliation and negotiation. With regard to mediation, we now have a new enactment of the Mediation Act of 2023. So there is an enactment, but it is yet to be notified because there is certain period that would be required in setting up the mediation centers and enrolling eligible candidates who could then be appointed as mediators. So this is the process that is been going on now for some time. Hopefully the enactment can be in operation completely in a few months' time. And thereafter, the last manner of resolving disputes would be the Lok Adalat. Now, Lok Adalat, for one to approach the Lok Adalat, you need to already have a pending case. Unless there is a pending case, you cannot refer the matter to Lok Adalat. However, if one is to consider a negotiation, mediation, and conciliation, these are all which can either these are all tools that can be adopted as at the pre-litigation stage. That is, before you have even initiated any legal proceedings, these tools can then be adopted to try to resolve the dispute. And I'm using the word resolve, not adjudicate. And you will understand the succinct difference between resolving a dispute and adjudicating a dispute by the end of the session. But let us first understand what is the history of mediation. Because mediation is a way to settle disputes. Now, settlement of disputes in an amicable manner has always been a hallmark of civilization. In ancient India, there have been mediation systems that has been prevalent in one form or the other. For example, if you all would be well acquainted that even today you have the panchayat system, and even today if there is any dispute between a farmer of having stolen another cattle from another farmer in a village, these issues are resolved by the panchayat, the sarpanch. So it is, our roots of mediation go back ever since civilization has come into existence. One such example is that of the panchayat system, which is still prevalent today. From that, of course, we have evolved. There have laws been enacted. You had the Arbitration and Conciliation Act of 1940, which thereafter there was a model law by the UNCITRAL, that is the United Nations Treaty and Trade Treaty, and they had enacted the model law. That model law was enacted by various members, signatories of the UNCITRAL, and thereafter only in the year 96, that is almost about 10 years after the model law came into existence with the treaty, is when we have adopted it in our domestic legislation as the Arbitration and Conciliation Act. But this is in the year 96. However, in the CPC, you would appreciate there is a provision that is section 89. Now, section 89 of our Code of Civil Procedure provides for resolving disputes alternate to that of going to a civil court. So, the Mediation Act, though, has come into the foray in existence, enacted in 2023, but the legislative intention was reflected through section 89 of the CPC that came into amendment in the year 2002. So it has taken almost about 21 years to codify Mediation Act. However, the Arbitration Act has always been there as part of our legislature, which is only getting refined and more efficient through each and every amendment. It has undergone amendment in the year 2015 as also in 2019, whereby there are some provisions which effectively try to resolve disputes, whereby one such example would be that now the timeline for resolving an arbitration proceeding is restricted to 12 months. So earlier we did not have any such cut-off timeline wherein which the arbitration proceeding had to be resolved. Today, if you look at the Mediation Act of 2023, it provides for 120 days in which the mediation process has to be resolved. So the legislature, of course, law is dynamic, it is ever evolving, but these are just certain salient features that I'm just pointing out, which you would appreciate only tends to ensure that you have timely resolution of disputes. Because if there is a dispute and it is not resolved in a timely fashion, then of course the entire charm of resolving a dispute is lost. And then it only ends up becoming a very tedious process. So today, what I would be touching upon would be now mediation in India, how that began, the legal recognition of mediation. Then I would touch upon what is a conflict and what are the stages of a conflict. Then you have causes of conflict, the concept of mediation, the types of mediation that we have, the advantages of mediation that we have, and the comparison between various ADR mechanisms such as conciliation, arbitration, and mediation. And then we will go on the process of mediation and the stages. And hopefully by the end of this, we will then be able to understand and appreciate why is mediation an effective tool? Why is it that you should be reading upon mediation, trying to inculcate your skill sets to resolve disputes through mediation, which in fact can help you improve your particular position in the company. Because today, whenever I have clients of MNCs and company secretaries come and visit me, and there are matters in which they engage me, the biggest foremost difficulty is that, sir, we are always at loggerheads with the business team. Now, the business team wants to make profits and they want to mitigate the risks. Now, for mitigating risks, company secretaries today are also burdened and saddled with the responsibility of being the law officer also of the company. Therefore, they need to resolve disputes efficiently, which means quickly and at a low cost to the company. Now, to resolve disputes efficiently, wherein again, highlighting those two major things of at a lower cost and quickly, you obviously need to then appreciate the importance of ADR, particularly mediation. So this is why appreciating mediation will definitely come to the aid and assistance of you all in your day-to-day lives, wherein you could then bring about the change in the company, and the pressure that the management and board has over the legal team, over the compliance team can be hedged in a particular manner, whereby certain proactive steps at your end of incorporating certain clauses in your agreement, such as a pre-dispute mediation clause, can really be helpful. So we shall then quickly touch upon mediation in India. Now, mediation in India, you would be surprised that before even the advent of the Britishers and the British India regime, we obviously had a strong trader nexus in community. Now, amongst this, one of the most popular community were the Mahajans. So the Mahajans would form an association, and mediation and arbitration were used as tools way back in the 1600s, 1700s, whereby there would be an association of all these traders and members. And if there was any dispute arising between these two traders and members of an association, the Mahajans would form a committee and they would try to amicably resolve the dispute. And they had one very specific understanding, customary practice, and this is very important. Back in the day, it was very clear that if a member of that association, the traders association, does not approach the association first and attempt to resolve the dispute through mediation and directly goes to court, he will then be removed as a member, which basically incentivized each and every member of the trader community to then first approach the association, exhaust the remedy of mediation, and only after exhausting the remedy of mediation would he then be compelled to go to court if he still continued to be aggrieved. Now, that is where mediation, in fact, through customary practices, goes way back in our 1600s. But unfortunately, though we may as Indians be well versed with our ancient scriptures and religious texts, we have not documented this. And which is why when there was an extensive research carried out by various think tanks, they had come across these such incidents. And that is how this came to be discussed before the Law Commission. And it is through the Law Commission's reports that I have in fact gained knowledge that this is when the first course of mediation had taken place in India. Thereafter, of course, we've had more once the Britishers come in, everything came to be codified. And then you had the Arbitration Act. And then, for example, the first mention of mediation would be in the Family Courts Act. Because in the Family Courts Act, there is a clear provision whereby the family courts have been given the responsibility to first ensure whether any dispute that comes to be adjudicated before them can be resolved through mediation. And that is where there was the first mention of mediation. Of course, thereafter, you had your CPC that was amended in 2002, whereby Section 89 provides for resolution of disputes alternate to courts. So, for example, if there is an arbitration clause, if there's a mediation clause, if there's a conciliation clause of resolving disputes, the civil court is barred from taking up any such matter unless, of course, that those steps have been worked out and exhausted. Of course, for arbitration, a civil court never will have jurisdiction. If there's a valid subsisting arbitration clause, then of course the matter has to go before the tribunal, and thereafter only the award can be challenged before the court. But for mediation and for conciliation, if there's any contract whereby you do not provide for arbitration, then of course, should the ADR steps not work out or not culminate in a favorable resolution, then of course the party will be constrained to approach the court of law. So this is the historical perspective. Now the legal recognition of mediation in India. As I said, you had the Family Courts Act. You also had something called as the Industrial Disputes Act. The Industrial Disputes Act also of 1947. There was a provision whereby they had promoted resolving disputes. Now, Industrial Disputes Act primarily discusses about employer-employee workmen disputes. So when there were claims of workmen, the Industrial Disputes Act provides for the settlement and resolution of these disputes at the first instance through mediation. So that is when again mediation found its first reference in your Industrial Disputes Act in your Family Courts. And now it has been codified and enacted as an act altogether in the year 2023. Thereafter, let us now understand that when we talk about resolving a dispute, what are the escalations of a dispute arising in the first place? So there are two parties. Those two parties would have some kind of arrangement. Now this arrangement can be an oral arrangement or it can be an agreement put in writing. Now, of course, any agreement that we have put in writing has to satisfy 5 conditions. There has to be, like, it's just a contract. There has to be an offer, valid offer, a valid acceptance. There has to be consideration. Now, the persons who are entering into this agreement need to have the capacity and competence to enter into such contractual obligation. So, if these 5 criteria are satisfied, that is when you can possibly have a valid and binding contract. Of course, it has to be enforceable, so it has to be within the laws of the country. That goes without saying, but these are the 5 crucial aspects that have to be satisfied. Now, once these 5 crucial aspects are satisfied, what then dwells upon the parties are the fact that there are rights and obligations that are created. Okay, so party A has certain rights, of which party B has to oblige contractually, for which party B is receiving consideration. Therefore, these rights and obligations are created by the contract. In this contract, when of course there is one party who has a right and who feels the right is not being enforced through the obligation that the other counterparty has to act on, is when there is a difference. So the difference could be that, according to me, this is your obligation, but according to the party on whom the obligation was cast, this is not the obligation that party B has to act upon. So the very first stage of dispute would be a difference. If there is a difference of interpretation, difference of understanding of what the contractual obligation is, that is the very first stage. Okay. Thereafter, once you understand that there is a difference, the next escalation of the dispute will be of disagreement, whereby you then strongly believe that it is not a difference of opinion, but in fact there is a disagreement to the extent that I do not agree with you because I am right and you are wrong. Earlier it was that I believe that this is how it should be read, but now it has gone to the stage that I am right, you are wrong. Now, when this happens, the third stage is that there is a problem. The problem is because parties now will not be communicating with each other. They would only be alleging and agitating the fact that one party is right and the other party is wrong, and therefore there would be no form of resolution. Now, when you have reached this, when you have arrived at this problem, the next thing is that you start disputing it. Now, you start disputing it by exchange of communication, exchange of legal notices. And that is when, after having recognized and identified a dispute and having acted upon and notified the other party by way of correspondence or notice, you have then reached the stage of conflict. Now, when you have arrived at this stage of conflict, is when you need to then adopt the remedy of resolving this conflict. Now, nowadays, any agreement that you enter into, unfortunately, through my experiences, the dispute resolution clause, the commercials will keep changing contract by contract, agreement by agreement, but unfortunately, you have your dispute resolution clauses which continue to remain the same over a span of time. And that is where you, as company secretaries, need to be really mindful and proactive and well aware of the ever evolving amendments and laws. Because I have seen that there are agreements in certain contracts that remain unchanged over the last 15 years of a company. And I was completely shocked. You have Supreme Court judgments whereby now you cannot have an employee of a company acting as an arbitrator. But these are the clauses that still continue even 5, 6, 7 years after such judgments have been pronounced. This is just one such example, which is why, and the difficulty is not on the compliance officer or the company secretary. The problem here is because of the pressure that the management puts in just getting the work orders executed immediately, that there is absolutely no thought given to the dispute resolution clause. The dispute resolution clause is crucial. Why? Because it is the dispute. To resolve the dispute, you need to rely on a clause. Now, that the contractual obligations that are cast have to also be resolved in such a manner whereby you are preserving the business relationships rather than terminating it once and for all. Which is why it is so said that alternate dispute resolution is based on two crucial principles. The first is of party autonomy. Now, party autonomy basically means and implies that the parties entering into the agreement have an autonomy of deciding what are the rights and obligations that they want to enter into. Should there be a difference, a dispute, a conflict, how have they amicably at the point of entering into the agreement chosen to resolve that said dispute? And this is most crucial, because at the time of executing an agreement, if one could fathom or be mindful that there is this particular risk wherein there may be a breach or default from the other party which needs to be remedied, let us try to adopt such manners of resolving the dispute which one would possibly say is the best suited to remedy the situation and preserve the existing business relationship. Because you do not want to sever business ties that are into existence over a span of years together. Now, to do that, you need to be sure of which is the alternate dispute resolution that you need to contemplate at the time of entering into any such agreement. I would always suggest that a multi-tier dispute resolution clause will be most helpful in resolving any kind of commercial disputes when it comes to a company. Now, what is a multi-tier dispute resolution clause? A multi-tier dispute resolution clause is wherein you have defined which clauses of the agreement are the clauses on which you may want to resolve the dispute using alternate dispute resolution, and which are the clauses that you would want to leave to determination by a court of law. For example, a recent matter of mine, there was an insurance company and a huge pharmaceutical company, and the pharmaceutical company was in the process of making certain new vaccinations. So the insurance company in its insurance policy made it very clear that if there are any deaths that arise out of the vaccine which is undergoing clinical trial, then the claim that you have for those deaths, we will not resolve it through alternate dispute resolution. For that, you go to a court of law. But if at all any of those claims are sanctioned by the concerned government authority, and there is any computational or clerical or arithmetic claim which the pharmaceutical company has put forth to the insurance company, and the insurance company has not processed or deducted, to only that extent the matter will be resolved through arbitration. So here, through this example, what I'm trying to tell you is that you can even segregate what are the kinds of disputes that you want to resolve through alternate dispute resolution, what are the kind of disputes that you would want to leave for court to decide. Now, how do you come to this? Whether we want to resolve this through dispute resolution or we rather have faith in court is something that, of course, you will only be in a position to understand depending on the very commercials of that particular transaction. But there, of course, are certain guiding factors which we will discuss. So, party autonomy is the first thing, and second is that dispute resolution is a creature of contract. Now, the power is in your hands because you would be the draftsman of these contracts. So you need to be mindful of what you put in the dispute resolution clause. Coming back to my point of a multi-tier dispute resolution clause, I would always suggest my clients to first try to negotiate the matter amongst yourselves. Now, the reason for this is that when there is a dispute or difference arising out of any such contract, and you believe that this can be worked out by just pure communication between two competent representatives of the counterparties, probably within a space of a week or so, then why do you want to burden the company or anyone to engage an advocate, to incur cost, to initiate legal proceedings? You will be surprised, at least in the Bombay High Court, there is this digital screen that every day I would look at when I enter the court premises, and on the screen I see that there are 70 lakh pending matters in the state of Maharashtra itself. You can imagine how many matters you would have pending in the entire country. Our courts, of course, are burdened. You know that vacancies are not being fulfilled. You know that there is how many matters can a single judge entertain in a day. Otherwise, also he has about 200 matters to handle. It becomes very difficult for an individual, for a company, in fact, to get efficient justice or get the claim settled by a court of law. A suit, on regular suit you file these days, a commercial suit you file these days, it takes nothing less than 5 to 7 years to get a judgment. And 5 to 7 years, can you imagine the risk that you are running with it in a court of law? Of course, you can be protected with the interest component, but today you do not know. There's a company that is in existence today, tomorrow it may be in NCLT, winding up, or some CIRP proceeding will be going on, and then you only happen to be another creditor. Now, to avoid any of these adverse circumstances, you need to be ensure that whenever there's a dispute, which is the best and effective, efficient manner to resolve it at the very nascent stage. Because then what happens is, if the dispute is not resolved at a nascent stage or the initial stage itself, it then results in far more complexities that can be very well avoided. Which is why I always suggest that you first invoke negotiation as an alternate dispute resolution mechanism, whereby there are two probably company secretaries of each company or a compliance officer of each company, of course under the supervision of the CEO, because they also need, the management has to be mindful of it, who would then be initiating some kind of dialogue which would be in the form of negotiation. You could possibly give a week's time to resolve the matter through negotiation, failing which then the tier 2 dispute resolution clause will be, the tier 1 will be negotiation, tier 2 will be that you try to resolve this dispute through either mediation or conciliation. So with mediation and conciliation, what happens is you have a third individual who is a professional who will try to facilitate a resolution between the two parties to the contract. Now, one very unique feature about resolving a dispute through ADR, apart from arbitration, and or going to a court of law with a claim, is the fact that when you go to court, and let's say there's a purchase order, you want to buy some engineering equipment for some industry, and you have just raised the purchase order, you have given your tech specs, your technical specifications, the goods come in, and you have been in business relations for over 10 years, and there are other forms of products also that you keep purchasing. What then happens is that, assuming for a moment the goods so provided are deficient or are not as per the technical specification, and you have to go to a court of law. In the court, the cause of action for you to go to court is the delivery of or non-delivery of the goods. Okay, so that is the cause of action. You will then file a claim saying that I had paid so much advance money, and this is the kind of loss that I have incurred because the said goods were not made available to me in a timely manner. The court will look at the fact that your cause of action is either bad goods have been supplied or no goods have been supplied. Then they will see that what is the loss or damage that is caused to you. And then within looking into the Evidence Act, looking into the Code of Civil Procedure, looking into the cross-examination of the other side, a final decree will be passed. Okay, this will be through the process of adjudication. Now, in this entire process, what the court does not have the benefit of is to, let's say, square off any losses or damages that has arisen in this contract with some other contract. Why? Because that is beyond the scope of jurisdiction of the court. Why? Because your cause of action has arisen out of one contract, and any breach arising out of that contract is what the court's limitation is, jurisdiction and limitation is restricted to. But when you are trying to resolve a dispute through negotiation, conciliation, and mediation, the sky is the limit. There is no restriction as such. Parties, if they want to resolve the dispute, can do beyond only one agreement. You may have 20 parallel agreements going on with the other side. Let's say there is a loss or some breach in one agreement that can be squared off or settled through some other agreement or arrangement. It is only through negotiation, conciliation, and mediation that these breaches can be remedied, agreements can be novated, and accordingly the business interest of the parties can continue. However, if you approach a court of law, the court can only then say that, listen, either it's specific performance where it will direct the other party to perform the responsibility as envisaged in the contract, or it can pay damages only to the extent of losses incurred. It cannot direct a party to enter into any third kind of transactions or amend the existing transaction. That is what a court does not have the power to grant, but can be achieved through effective and efficient mediation, conciliation, and negotiation. Right? So now let us go on the types of mediation. For mediation, we have two types of mediation. One is court-referred mediation, and the other is private mediation. Now, court-referred mediation would be wherein, of course, you have approached the court, and the court believes that this matter can be resolved through mediation, appreciating the fact that there may be certain underlying discussions, some underlying arrangements that can be best handled out of court across the table, which possibly may not be in the best interest of parties should they want to agitate their claim before the court. Because as I said, court has limitations. The limitation of the courts are restricted to the statutes, the statutory provisions and the interpretation of law. You cannot go beyond it. The moment you go beyond it, then the decision of that court is susceptible to challenge before a higher court. And all these transactions that you would be having are all commercial transactions at the end of it. One thing that I have understood in my practice is when it comes to business relations or business transactions or commercial transactions, time is of essence. The value of money that you have today may not be the value of money 10 years later, even with the interest component involved. Because you do not know whether today the biggest challenge is you do not know. Of course, if you're in a tier 1 company, you're doing well, but you know the bubble can burst at any juncture. Any company can be facing any kind of threat or liquidation or winding up proceedings or SFIR proceedings. You do not know. You do not want to be stuck up in a position whereby you are a credit-worthy company, but you have not money in a timely fashion. As a result, that only deteriorates the condition rather than salvaging it. So therefore, there are two forms of mediation. One is court-referred mediation. Or court-referred mediation, as I said, family courts is where it started, whereby they would always first refer the matter for any matrimonial dispute between spouse to a mediator. A mediator, there is no specific qualification of a mediator, but it was always understood that it may be a senior respectable member of the bar and advocate or a retired judge. Thereafter, we had the Commercial Courts Act of 2015. Now, the Commercial Courts Act defines, so the Commercial Courts Act of 2015 has defined what is a commercial dispute. Simply put, any contract which satisfies the definition of a commercial suit would have to be determined, adjudicated by a commercial court. Now, in 2015, the legislature, in its wisdom, thought it prudent to ensure that every single commercial suit would have to undergo a mandatory process of mediation. So, I will give you an example. A matter of mine, there were certain loans advanced. These were private loans advanced to a foreign entity for the sale and purchase of certain, again, these were medical goods during the COVID time. So a third party defaulted and the dispute arose because long-standing payments were not made. So a summary suit was filed because there was an admission that this is the liability. So there was an admission by my client that about 6 crores of money is due and payable to the lender. Based on that, he filed a commercial suit in the Bombay High Court seeking damages of 6 crore rupees along with the interest component because it is an admitted liability. Now, thank God for the Commercial Courts Act, because then what happened is we had to undergo mandatory mediation. So what then happens is you file your suit in the High Court. The High Court will then, because it's a commercial suit, refer the matter to the mediation cell of the High Court. The mediation cell appointed and engaged a elderly senior advocate, a seasoned senior advocate who has been in the practice of mediation and arbitration. And the matter was referred to the said gentleman. Now, because he had the experience of resolving commercial disputes, and we had the luxury of time to sit across the table and have open, without prejudice discussions, we were successful in resolving the dispute, whereby our client was, let's say, liable to pay about 3.5 crore rupees out of 5 crore rupees. That was the claim. And we were given an EMI option. And I can tell you that that mediation was successful. The report was sent to court, a decree was passed, and till date, the client is honoring the said commitment. Now, this manner of resolving the dispute through EMIs or giving some upfront advance is something that can only be resolved by an understanding that has arrived between the parties in mediation or conciliation. But a court can never direct the party. Once it is given a claim and it has to adjudicate whether this claim is a good claim or a bad claim, the court cannot then direct, okay, fine, I think that it may be difficult for the defaulting party to satisfy this decretal amount, which is why I will give the defaulting party an opportunity to repay in an EMI basis. So this is something that is beyond the scope of a court. And this is how mediation, in fact, is helpful in resolving the dispute. So you see, this is another subtle difference of how the dispute was resolved, wherein the money was being repaid on a timely manner instead of the dispute being adjudicated, whereby probably the court after years would have said that, yes, you have defaulted on this amount, which is why you are due and payable to pay XYZ amount. And thereafter, you would go for execution of it. By then, again, it may so have happened that the company may not have been in existence. So this is why you need to resolve the end. Another crucial aspect, all this is confidential. So no one knows about it till, of course, it becomes a decree. Then the fact is it's timely. It probably, I believe this mediation process was concluded in 2 months' time. If otherwise we had to litigate this and challenge this all the way to the Supreme Court, at least 10 years is something that it may have taken to get finality. So you have saved 10 years time. Of course, you had to dock a little of your claim amount. But again, as I said, money in hand today is better than some anticipated funds along with interest in the future. So this is court referred mediation, whereby you are directed to resolve your dispute through mediation while you have first approached court. Second, of course, is private mediation. Now, private mediation, as I've told you, comes in your dispute resolution clause. That is when parties to an agreement have decided amongst themselves that they will want to resolve their dispute through mediation. So here the mediation process will start the moment you have notified the other party that this is a dispute that has arisen out of this contract. You are in breach of these conditions, which is why I am entitled to claim XYZ from you. Because this dispute has now arisen and we have entered into an agreement whereby there's a dispute resolution process, we need to resolve this dispute as per the dispute resolution process, which then contemplates mediation. So you will notify the other counterparty that because of the dispute in different reason, in compliance with the dispute resolution clause, you would want to resolve this dispute. If you have so provided for mediation to be your first or only manner of dispute resolution, then of course the matter will be referred to mediation. Now, whether it will be referred to a mediation center, whether it will be referred to an individual, that really depends on what the parties to the contract have arrived at that particular point of time. Which is why it is very important to be very clear at the time of drafting the dispute resolution clause that who is going to be the mediator. Okay, it may not be an individual, it may be a mediation center. Because of COVID, the judiciary had to come out to resolve disputes by encouraging video conferencing. And because of video conferencing, the boom in video conferencing, a lot of dispute resolution centers have come up since the last 3 years, whereby now you have online dispute resolution centers. So they only resolve disputes online. If you do a little research, there would be about at least 10 to 15 such online dispute resolution institutes that provide the services of resolving disputes online, and you may then want to inculcate their dispute resolution clause in your agreements to facilitate any kind of mediation or conciliatory or arbitration process or proceeding. So that can also be a very helpful tool or thought at the time of drafting the dispute resolution clause, any which way. So in the private mediation would be again any dispute arising out of the contract. Parties have agreed that they want to resolve this dispute through mediation. They have mentioned in the agreement how the mediator will be appointed, what is the duration of mediation, what aspect is going to be mediated upon or not, and based on that, the mediation process can be initiated. So again, court related is when you go to court and it is statutory, or when the court deems it appropriate, of course, with the consent of the parties. Please understand one thing, that any alternate dispute resolution mechanism is only driven by the consent of parties. It is only when the parties consent that the matter can be referred to mediation. That is, if it is not a court referred or it is not a statutorily mandated mediation. For example, MSME Act compulsorily provides that if there is any dispute that has arisen between an MSME and another entity, then all those disputes have to be referred to the Facilitation Council. And the Facilitation Council has to first ensure that there is a conciliatory process, failing which arbitration will then be initiated. So here you may not have an express consent between the parties, but it is a statutory provision whereby you are mandated to undergo the process of conciliation. Similarly, under the Commercial Courts Act, it is a statutory provision, you have to compulsorily go for mediation. In certain other matters, the court may feel that matter requires to be worked out because of the facts and circumstances of the case, and with the consent of the parties, the matter is referred to mediation. So it can't ever be that you are forced to go for mediation unless statutorily provided. So I hope I make myself very clear there. Private mediation, of course, just to repeat and reiterate again, the parties have, at the time of executing the agreement, consented that if there is any dispute that arises out of this contract, has to be resolved through mediation. So there also you have consent. Minus consent, you cannot be compelled to undergo any dispute resolution process. Now, let us talk about the advantages of mediation. What are the advantages? Now, parties, so first and foremost is that the parties have control over the mediation. Now, what would you say would be control? Control is the scope. That is, the terms of reference or the issues that are involved in the dispute can be limited or expanded during the proceedings. And its outcome, the right to decide whether to settle or not, and the terms of settlement. So these are the controllable factors that are in your hand. What is the scope of mediation? It is up to you. It can be as little as this. It can go to the level of your imagination or creativity. Okay? Because there is no limitation. There is no limitation of a court, which is why the scope is wide. You can try to resolve all your commercial disputes through adopting mediation. And what is the second thing I said? It is that whether this decision is something that you want to accept or not is also in your control. To which you may ask then that, okay, we have negotiated, we have discussed, but the defaulting party does not agree for this. How do we compel them? You can't compel them, but you can incentivize them to understand and appreciate that today, if you accept this offer, it will be in their better interest rather than being sued in a court of law and then, undergoing the rigors of trial and eventually damages and interest and execution proceedings, whereby, you can even get the company liquidated or auctioned off, and goods and services, goods can be attached. The buildings and removed property can be attached and auctioned off. So all those embarrassing procedure and steps can be avoided should the offer be accepted at the mediation stage. Now, second thing is that mediation is participative. So parties get an opportunity to present their case in their own words and to directly participate in the negotiation. So what does this mean by, do you not participate in court? Yes, you do, but you're represented by an advocate. An advocate can only make submissions that are tenable in law. Here, an authorized representative, please understand, authorized representative of a company, that can be very well you, a company secretary as well, can participate in mediation. You do not need to be a qualified lawyer. You can very well participate in mediation, and you can have very open and clear discussions. Such discussions that you can never have in court. Because of course, in court, you would have lawyers on either side who would be guiding and advising clients how to best present their case, wherein there may be certain documents that are officially available, there are certain documents that are not available, but one is mindful of it, but they may not be comfortable to produce it in court because it may have some backlash. Now these are open discussions that you can have in a mediation proceeding, which you cannot have in court. That is why, again, it is a better option to resolve your dispute through mediation rather than going to court, because of the without prejudice discussion that you have. Now, without prejudice basically means that these discussions that you will have during mediations can never be used or cited or referred to in any court of law. It is as good as these discussions never having taken place. But should these discussions fructify and you have a positive result and outcome, then definitely parties will then, after they consent for the said decision to be made applicable on them, binding on them, is when the decision will be binding on them. But till then, they can have free discussions, which are called without prejudice discussions, because they do not prejudice the matter that is ongoing or likely to be initiated in any court of law. Then, of course, it is speedy, efficient, and economical. As I said, the new Mediation Act provides for resolution of disputes within a period of 120 days. What is 120 days? 3 months. 4 months, sorry. Within a period of 4 months, that is the maximum period within which you have to resolve the dispute through mediation. If you are unable to resolve the dispute through mediation in a period of 120 days, it is extendable, I believe, to another 30 days. And thereafter also, if you cannot resolve your dispute through mediation, then of course you have to go to court of law. But the period in which you have been trying to mediate will not be counted or considered as the limitation period for having moved court. So that is how the legislature also first wants you to try to resolve the dispute out of court through mediation, failing which, then of course, one has to have complete faith in our judicial system. It is efficient. Why is it efficient? Because, as I said, it does not have boundaries. You can resolve anything as long as it is enforceable in law. It may not restrict itself only to one agreement or one arrangement, but it can transcend the commercials of one agreement so as to ensure that the business relations between the companies continues to be maintained. And third, of course, it's economical. The amount of money that you may spend to resolve a dispute through mediation won't even be a fraction of the amount that the company may incur in resolving the dispute by going to court or by having an arbitration proceeding. Next, it is mediation. It is simple and flexible. What happens in a mediation process? There is a mediator. There is both the parties, the representatives. So you would have a simple conference room discussion whereby the mediator will just have informal discussions with both the representatives of the concerned parties to the agreement. And so it is not complex whereby you have to attend court. There is certain court decorum and discipline that you have to maintain. There is a particular fixed time. So time, because it's flexible, you can even choose the time slot that you want to have your mediation, unlike court. If you want to have video conferencing, that is also then available. It saves the hassle of travel. For example, in any cosmopolitan city, just to reach from point A to point B and back to point A can take more than half your day. But you can have the benefit of video conferencing for mediation, and from the comfort of your own offices. Efficient, effective session can take place for 30 minutes an hour through video conferencing. Then the process that is conducted is informal, it's cordial, and it's conducive. Because unlike, again, the comparison here is that with any judicial process. So in judicial process, of course, there are your court mannerisms, etiquettes. It's not that you can speak unparliamentary language before a mediator, but the reason why there is this freedom is so that you can express yourself, you can ventilate, you can express emotions, and at the same time, the mediator can also then understand what exactly pinches the party, because at times on paper, what may be reflected to be the breach may not be the actual pinch that one party feels. It could be something else, and that is something that can be best understood in open dialogue and discussion. And to facilitate open dialogue and discussion is why mediation is this informal, cordial, and conducive in comparison to a court of law, whereby if even there is a remotest statement that is made which is not thought through well, and the court feels that the majesty of the court is brought down, then there is a lot of contempt action also that can be initiated against litigants and advocates. Then mediation, of course, it's a fair process. Not to say that courts of law are not fair, of course they are. But here what happens is usually you have a mediator who will be impartial, neutral, and independent, and unlikely to have any kind of pre-existing relations with either of the companies or the representatives. The benefit of having such an individual is, of course, he or she will have profound knowledge in resolving such commercial disputes. And the fact that when you are not professionally or emotionally attached to any one party, the other party also has that much of faith and trust that an independent, impartial individual will be in a position to try to have the parties to, arrive at some kind of point of settlement. There could be some meeting of minds with an independent professional, as opposed to the fact of a professional who may have acted or appeared on behalf of one such party, because then the counterparty will always have it in their mind that there may be a sense of bias. And the moment the sense of bias creeps into a party, of course, then instead of taking one step ahead of resolving the dispute, they take two steps behind, with the thought in the mind that, this discussion is only going to be prejudicial and biased against us, which is why they may not be inclined to resolve a dispute which was resolvable. Then we have the fact that it is confidential in nature. So at the pre-litigation stage, you would know that, let's say you are a company secretary of a public listed company, you know that you have to give annual disclosures and quarterly disclosures of any proceedings that have been initiated by or against the company. And this can really affect the market value of the company. It can be reported in the newspapers. It can scuttle a lot of business deals. So one benefit of mediation is the fact that because it is confidential in nature, the dispute can be resolved in utmost confidentiality. It will not have any public cry and may not adversely affect the reputation, business, and goodwill of a company, which is why they would then want to consider resolving the dispute through mediation rather than accessing court, because the moment you go to court, then of course it becomes a public document. Now, mediation also is beneficial for the simple reason that it leads to effective communication. When you can have effective communication between parties, I believe the best way to resolve any dispute is first to have effective communication. If there is effective communication, of course, you have already identified the problem. You have understood each other better, and when you have understood each other better, then there is a better likelihood of them appreciating the possible practical solutions also that could come about resolving this dispute. Now, this effective communication cannot take place in a court of law for the simple reason that in court, it would be your case against the defense that is raised by the other side based on the facts and the evidence that is gathered. There is no question or no scope of communicating with each other. You are then only contesting the matter against each other. But in mediation, of course, you will then be having effective communication, which is almost as good as resolving half the dispute itself. Thereafter, one more important aspect, again, in the event that you want to maintain your business relations, then you can obviously opt for mediation, because that is a pre-litigation. It can also be a mid-litigation or post-litigation. Mediation is also possible. It is not that you can have mediation only before a dispute has arisen. You'll be surprised that even after courts of law have passed orders, there are parties who have sat together, who have worked out the matter, and those through mediation, and they have arrived at certain consent terms whereby they have even nullified the effect of the order that has been passed by that court on that day by coming back to court and getting the order revised. So it really depends on so that is basically the stages at which mediation you can of course invoke. But as I was saying, we were talking about mutually beneficial relationships. If you want to preserve your business relationship and ensure that there are more business that is being generated from both party and counterparty, then mediation is one better way of resolving the said dispute, because it is very unlikely that once you go to court and you are contesting a process, a matter, and the court has adjudicated the proceeding, it is very unlikely that your business relations will continue for some other contracts or for some other deals. It's very unlikely. Mostly once you have gone to court, then it's almost the end of any future prospects from the same counterparty. And there again, so you can also settle any unrelated or connected cases through mediation. There may be cases, so for example, let me just tell you, there is a limitation period of 3 years to file any kind of claim for recovery. Okay. Now, assuming for a moment that there was some claim of yours with that same party, which you for some odd reason could not claim in a period of 3 years from the cause of action, you can bring that aspect out in mediation and try to resolve that dispute also, which stands extinguished on under law through limitation. So these are also things that can be discussed in mediation. As I said, anything under the sun can be discussed in mediation. What can be executed is only that what is lawful. I am just looking at a few questions that have been asked thus far. I will try to address them at the end of the session. So you guys are at absolute liberty to keep raising all your questions, because what I think then I will address it at the end, because I see that there are quite a few questions coming in, and I'll just get done with my session and then take up those questions. Then another crucial aspect, and this is something that you must make a note of, because it has a commercial angle to it, and that is that if you have, let's say, I am giving an example, if you file a suit in a court, you have to pay court fee. Okay. Now, for example, the Bombay High Court, if you're filing a suit of defamation of 100 crores, if you're filing any suit in which the claim amount is over 1.5 crore, then your court fee, that is the maximum court fee as on date, is 3 lakh rupees. Okay. But after filing such a suit in the High Court, if you have successfully resolved your dispute through mediation, you are then entitled for a refund of court. When you proceed to get a suit adjudicated by court, there is no question of refund of court. But here, when you have resolved the dispute through mediation, even after filing a case, and the dispute stands resolved, then you are also entitled for a refund. And that is also another incentive why one should opt for mediation and an alternate dispute resolution rather than proceed with proceedings, the regular proceedings before a court of law. So these are broadly the advantages of mediation. Now I will take you through the difference between mediation, arbitration, and a normal court proceeding. Right? We should understand what is the succinct difference between these three, and why would you say that at which juncture would you want to opt for which form of resolving the dispute. The judicial process, as I said, it is an adjudicatory process. It is resolved by the decision of a court. Arbitration is a quasi-judicial adjudication. So, what is the difference between a court and arbitration? The word quasi-judicial, what difference does that mean? If you are before a court, at that particular juncture, you have already invoked proceedings. There is no question of settling or resolving the dispute in any other manner rather than your claims being determined. Okay, so you cannot opt out of court proceedings saying that I did not agree for this, I did not consent for this. If you are the defendant, of course. If you are the claimant, you may not want to invoke that remedy, you may not want to file your case, you may want to consider it to be a sunk cost depending on whatsoever the issue is. But once you are a defendant or a respondent, that is the defaulting party, you cannot say that I do not consent to this case being filed against. You can take legal defenses such as the court does not have jurisdiction to entertain this matter. You can take legal defenses that the breach as alleged by the claimant is in fact not a breach and you have complied for. But you can't opt out of the entire proceeding saying that I did not consent. In arbitration, once there is a dispute resolution clause in the contract saying that parties have decided and agreed to resolve all their disputes and differences by arbitration, that is consent enough for the arbitration proceedings to be initiated. You cannot, after that, executing that agreement, then take the defense or then try to opt out of the arbitration proceeding. That is why it is quasi-judicial. Quasi-judicial, why? Because you have privately accepted that you will not be going to court to resolve this dispute, but you would want this dispute to be resolved through arbitration. And arbitration is a codified enactment under the Arbitration Conciliation Act. The powers of the tribunal are similar to the powers of a civil court. So the arbitrator tribunal passing an award is equivalent to a civil court passing a decree by law. And that is why it is a quasi-judicial body. Mediation, on the other hand, it is a negotiation. It is not an adjudicatory process. Right? Which is why you can consent to attempt to resolve your disputes through mediation, but you can always opt out if a proposal that is made by the other party is not commensurate or is not worthy of settlement or acceptance by you. You cannot be compelled to accept the outcome of a mediation session. So the power still remains in your hand. So that is the first point of difference between a court, arbitration, and mediation, wherein the decision is not binding in a mediation process, which unfortunately will then be binding in a court or an arbitral process. Then your procedures and decisions before a court are governed by various statutory provisions. Similar is the situation with arbitration. So basically, there is a free hand for the parties to try to have as much discussions so as to resolve or settle the matter. So as to resolve the settled matter, there is no stringent procedure prescribed, which is why it is more informal, and it is basically being informal, it is more conducive for a settlement as opposed to the other judicial processes. Then, as I said, the court's order is binding. The award of the arbitration is also binding, but only a binding settlement in a mediation is in fact enforceable. If you do not have a binding settlement, which means that if both parties have not signed on the mediation report saying that we accept to this settlement proposal, it will not be binding. Court proceedings are adversarial in nature. So there will be allegations, counter allegations, proving a case or disproving the case. Same is the case with arbitration. But mediation is not adversarial, it is collaborative in nature. Collaborative in nature basically means that both the parties along with the mediator are trying to reach out at a settlement, are not trying to fight it out, but are trying to see how best settlement talks can be explored so as to ensure and maintain the interest of all. So here you are taking a collaborative effort to resolve the dispute, whereas in arbitration or in court proceedings, it is an adversarial stance that your case is false or my case is true. That is not the case with mediation. In courts and arbitration, again, your personal appearance or active participation is not required. In courts, most definitely not if you have engaged an advocate, but of course, a party in person can appear. Companies obviously deem it appropriate to engage a lawyer who can appear in the arbitration proceedings and represent the best interests of the company. But for mediation, you do not. There is active and participatory role by the representatives of the company. So here is where the business team concerned member will get an opportunity to voice out his commercial understanding. The company secretary is being skillful enough, can be the spokesperson for the company along with the business team member. You can have such discussions in mediation process, which discussion you can't ever have in arbitration or the court proceedings, which is why this is again one unique quality of mediation over court proceedings or arbitration that is really mindful. Then you have a formal proceeding. The court proceedings are formal proceedings that are held in public, and they follow strict procedural stages. Say with arbitration, it is a formal proceeding, but it is not held in public, so there is confidentiality, but the nature of formality still remains. In mediation, it is neither a judicial nor a formal process, neither is it in public. So that is also one succinct differentiation, whereby not only is the confidentiality also maintained, but you do not have to adhere to strict formal procedures. Then, with regard to decision, now if a court has made a decision, that decision can be challenged by way of an appeal to a superior court. For example, if it's a decision of a district court or a civil court, you can file an appeal with the district court. After district court, you'll go to the high court. After the high court, you'll go to the Supreme Court. Once the Supreme Court has dismissed it, you'll still try to file a review petition. Review petition is dismissed, you'll still try to file a curative petition. But there is scope of appeal and challenges, which is why it takes time. With regard to arbitration, once the award is passed, you have only 5 grounds of challenge. Only 5 grounds, and you can put in a challenge. But in mediation, if the parties have agreed for the outcome and they have signed the settlement agreement, then unless you are making out a case that fraudulently a party has signed it or was forced to sign it, it will always be binding. There is no appeal against such kind of settlement terms that have been entered into before a mediator. So that's another good benefit of mediation, that once you have finally resolved a dispute, you do not have to be burdened in your mind that said dispute is appealable. Unless, of course, it is a case of fraud, for which you have to establish that it was a fraudulent act, which is highly unlikely in today's day and age, but still. Then again, with regard to communication, I think I pointed this out. In courts, there is no opportunity to communicate with each other. In arbitration proceedings also, there is no opportunity to communicate with each other, but mediation is all about communicating with each other. That's also a very crucial aspect. And lastly, you have fees. Now, when it comes to court, you have to pay court fee. When it comes to arbitration, you have to pay the fees of the arbitrator, the tribunal, the secretaries, the conference rooms, the advocates. So it comes out to be a very expensive affair. In mediation, it is a very paltry sum, very, very paltry sum. And in fact, in private mediation, you don't even have to incur any cost. But if it's court-directed mediation, then of course, for a dispute going in crores, the mediator would barely charge you a few thousand. That is how reasonable it is when one has to consider for mediation. Now, we will just quickly go to the stages. Quickly, I'll just tell you the stages of a mediation. Now, just assuming that there's a dispute that is arisen and the matter has been referred to mediation, what exactly happens before a mediator? It's in fact not much that you can't imagine. But, the first would be the introduction and the opening statement. Now, in the introduction and opening statement, what happens is that the mediator will first inform the parties how the mediator has been appointed. That is, has been appointed by the mediation cell. The mediator will inform the parties that this is the claim on the basis of which the court has found it appropriate for me to mediate this matter. After that, the facts of the case are put to the knowledge of the defaulting party and said that this is what the dispute is, this is what these people are claiming. Then opportunity is given to the claimant to put forth his case. Why did he have to invoke mediation? Where was the difference dispute? After the claimant has said his entire piece, he would have the defaulting party, the respondent. Their representative will be suggesting how the business relations were, whether disputes were arisen, in fact, has been arisen or not, whether it is whether in fact it is admitted, accepted, whether they wish to resolve this or not. So there is this first opening statement. After this opening statement, and broadly everyone understands that what is the discussion and communication that will take place before the mediator is when you have a joint session. Okay, now this your first introduction is done by the mediator. Thereafter, briefly, the mediator just calls upon the parties, introduces them. In the event, there are also at times that advocates are engaged for mediation processes, wherein the advocate would then address to the other side, informing them that this is their case. Thereafter, there's a joint session. Now, in a joint session, what then happens is that the mediator would just observe quietly and say that please communicate with each other. So the first introduction session, the mediator's responsibility is to ensure that everyone is well acquainted with each other. They are comfortable with each other. Mediator has expressed himself or herself about the appointment, the fact that, he's an independent, impartial person. There's no professional engagement or relation in any manner whatsoever with each other. And the fact that the mediator would be putting in best efforts to try to resolve this. Second session, as I said, is the joint session whereby the mediator will observe what the party has to say to each other. He will ensure that there is a decorum and discipline during the proceedings. He will make a note of whatever discussions that have taken place between the parties, and then he will prepare a strategy. The strategy will be such that he will make a note of what are the major issues that have been raised by one, how they have been countenanced by the other, and to what extent it has been accepted by the party so raising the issue. So all these notes and observational behavior is what the mediator will be doing in the joint session. After the second stage is complete, so first is introduction, second is joint session, third is a separate session. Now what happens in a separate session is that the mediator will have an independent and isolated discussion with each party. So after observing the proceedings that have taken place in the joint session, the mediator will have the benefit of knowing and understanding that on paper, of course, this is what the claim is, but amongst the discussions and understanding between the parties, these are the main points, major points of conflict. This is what the suggested outcomes and solutions are. So how does each party take to it, accept to it, and what are their views? So this will happen in the third session, which is called the separate session, whereby the mediator will then propose certain propositions that have come from either part, from the counterparty, understand the interpretation and the background of the party in default, how they want to address it, make a note of it, have the same kind of independent session with the claimant party, and after the third session is complete, that is the separate session wherein you have with each party, the mediator will then have a complete idea of whether this is a dispute that could possibly be resolved or could be resolved with some difficulty, could be resolved with certain incentives, or cannot be resolved at all. After this third session, you have then what they say the final discussions, whereby the mediator will be putting forth to each and every, to both the party in the closing. It's called the closing. The fourth is the closing, whereby the mediator will put forth to the parties that party A had this issue. These are the grievances that it had raised. Party B had these defenses. This is how they have countered it. In the private sessions that remain confidential, which the mediator cannot reveal the discussion, but can obviously nudge the party to say that I believe that should this proposal be worked out by you in this particular manner, the other party may be a little bit more receptive, consider it. So it gives time to the parties to go back, do their research, scrutinize the proposals, counter proposals that are made to each other. And after that, the parties then call upon the mediator, informing whether in fact another sitting or session is necessitated or required. In the event it is so required, there will be another session, and in that particular session, the mediator will only try to suggest that this is the solution that party A had suggested, this is B had suggested, this is what I personally think, but the mediator can neither advise nor impose. The responsibility of the mediator is only and only to facilitate communication between the parties, to facilitate the thought process of arriving at an amicable resolution, because the mediator does not have that power. He does not have powers to adjudicate, he does not have power to impose, he does not have power to advise. But what he does have is the freedom to facilitate. Now, to facilitate, of course, You have to sway the discussion in a particular manner which is more which obviously is more reconciliatory rather than more adversarial. And to ensure that, you need a professional who has had adequate experiences, exposures of seeing how these commercial transactions take place. What the mediator can also do is cite some other examples which have been successful, which have been approved and which have then been decreed, which are in public domain, whereby he can say that, in similar matters, such was the way out, we want to really consider it. So these are things that can be discussed in the mediation, and thereafter, and only after the parties have agreed to resolve the dispute, but in those specific settlement terms, will there then be an agreement which will be signed by other party, and once it is signed by other party, the mediator will then make a report, and only after making that report will that report be referred to court, and based on that report, the court will then just pass a decree. But of course, in the event the mediation is not successful, then the mediator is bound only to record that settlement could not be arrived. Any discussion that has taken place during the mediation cannot ever be cited before any other court of law or any public forum. It stands to be without prejudice discussion. Doing that, in fact, will not at all affect your case on merits and will be completely discarded, and whosoever has attempted to take undue advantage of such material will be put to cost and sanctions by courts of law. So that is usually how you have a mediation proceeding and setup. Now I'll just try to address some questions. Agarwalji, there are some questions that have been raised.
Yes, sir. You can start from serial number 6, sir.
Yes. So here there is a question of how and where to register to act as a mediator, conciliator, and arbitrator. Now see, there are centers. Now, for example, I believe Mr. Agarwal himself is setting up a mediation and conciliatory center with the ICSI. So as professionals of having more than 10 years of experience, you are qualified to be, by the Arbitration Act, you are qualified to be an arbitrator. Now the question is how and where to register. As I said, there are various institutes that have come up, particularly since 2020. I'll just name a few, but you can Google it. You have SAMA, that is SAMA. You have CADR, that is the Center of Arbitration Dispute Resolution. You have CORD, that is Center of Online Dispute Resolution. Now, these are various institutes that have been created which want professionals like you and me who can possibly be appointed and engage as arbitrators, mediators, and conciliators for various proceedings, because you will appreciate that the entire resolution process has to be done by an individual who does not have any kind of professional attachments or engagements in the past, which is why there will always be a dearth of resolutionary professionals. So you can get yourself impaneled with these various private institutes. After gaining some experience, you can then approach various courts of law and say that I have already appeared as a mediator, a conciliator, and arbitrator in over 10, 20, 30, 50 such matters, which is why you should consider impaneling me on your panel also. So thereafter, what can happen is that once you have adequate experience of handling, resolving disputes through the ADR methods, you can make an application to a court of law, and the court, for example, the High Court or the Supreme Court, they have their panels. They can then impanel you based on that experience that you have. There are also various other prestigious centers such as the Mumbai International Arbitration Center. So once you have had enough exposure in resolving disputes and high-stake disputes, then you can even raise the bar by approaching international arbitration dispute centers to be impaneled as a mediator or a conciliator or an arbitrator. So I hope that question stands answered. Then the next question I see, Mr. Agarwal, is whether mediation overrides the power of commercial courts. And then what are the cases that will be referred to commercial courts? Okay. So as I said, the Commercial Courts Act, specifically in clause 2C, defines what is a commercial dispute. Basically, you can consider if there is any recovery of money or any damages that you are seeking because of any breach of any contract would be classified as a commercial suit. Okay. Now, whether mediation overrides powers of commercial court? No. As I said, mediation is a process whereby parties try to resolve a dispute. You cannot be compelled to accept any kind of outcome. That outcome, in the sense, you can only have an outcome when there is consent to the parties. Excuse me. When there is no consent, then the matter will go back to the commercial court for the commercial court to adjudicate the dispute. So it can't be that mediation will ever override a commercial court. Mediation is a part and parcel of the Commercial Courts Act, which is the very first stage. If you are successful in resolving the dispute at the first stage, then of course you don't have to go down the adjudicatory route to commercial courts. But of course, if you are not successful, then as the matter will be decided as per the commercial courts. Then we have corporate civil suit for recovery, whether mediation is mandatory before proceeding before the court. See, now whether you are a corporate, you are an individual, you are a proprietor, you are a partnership, whatsoever you may be, only and only if you come within the ambit of the Commercial Courts Act is there a mandatory requirement for mediation. Mandatory requirement. If you do not fall within the ambit, for example, if there is an intellectual property right suit that you have filed, okay, an intellectual property right suit saying that someone has infringed your trademark or violated your copyright, and you have filed a suit for injunction and for declaration. Now, this is not a commercial suit, but even in these suits, if both the parties agree, you can very well go for mediation and try to resolve the proceedings through mediation. You do not have a mandatory requirement, but that option is always available should the other side want to consent. I hope that question also stands answered. Whether private mediation is expensive? No, not at all. It is rather one of the most economical manners of resolving disputes. Criteria for remuneration. I believe, criteria for remuneration, I believe this would be the remuneration of the mediator. If there are centers through which you are seeking the assistance of appointment of mediators, then they have their fee schedules. If you are otherwise wanting to provide for a fee schedule in the contract, you may so provide. And this is a very good and smart thing to do, whereby you then specify that within a week, if you fail to negotiate, then you will get the matter to mediation in your dispute resolution clause. The cost of mediation will be XYZ. So you can even limit and restrict the cost that will be the remuneration of a mediator. So whosoever will be appointed will know that he cannot charge more than that amount that has already been prescribed in the contract. I have then been put a question of, is the decision of mediator binding on the parties? No, I think I've answered that. What are the qualifications to be a full-fledged mediator? The Mediation Act right now, in fact, provides that any person of any nationality can be a mediator. So, but of course, if you want to be an efficient and a popular mediator, you have to start from somewhere. Now, if you want to start from somewhere, the easiest way to start is by becoming empaneled with any of these institutes. For that,
we can become the mediator here also in ICSI ADR Center, which we are going to have.
Correct, sir. So, but one thing people have to be mindful of is, if you are an employee of a company, so if you are a company secretary working in the company as an employee, you will have to rework your service conditions with the HR, because ideally the appointment letters are such that you cannot enjoy any other office of business, or you cannot have any other private engagement. So then you have restricted yourself to your own service conditions. But if you are independent, of course, and having almost about 10 years of experience, then you can very well be empaneled with a lot of prestigious centers in India. I have another question of, kindly brief on the limitation aspect, whether mediation period would be under the limitation period. See, now limitation period basically means, as I said, if the cause of action, for example, if there's a breach of contract and you want to recover money or seek damages, from the day of your cause of action, there are 3 years period within which you have to file a case. Now, if it so happens that in your second year and 11th month, you have filed a case, but you have invoked mediation, then that period of mediation till it gets extinguished will not be counted as a limitation. So assuming mediation fails, your period will be then counted as 2 years and 11 months. from the day on which the mediation process started. So it won't be that because this can be abused by the other party just to prolong the matter so that you are out of the limitation period. Then is, can we claim refund of court fee if matter is settled through mediation? Yes, you can. I think I addressed that. You get a complete refund. What is the legal force of issued through mediation? Can a party disown the order? There is no orders that is passed in mediation apart from the fact as to when is the next date of mediation and who is going to attend the mediation. There is no orders. Firstly, in mediation process, there is no concept of passing order. It is only a concept of arriving at a settlement, an amicable settlement, a settlement that is recorded in terms and conditions, which is signed by parties. So that mediation report is then sent to court, and the court, based on the mediation report, will then pass a decree. Okay, so there are no orders that are passed in mediation. And if you do not accept the discussion, then the mediator is then bound only to say that the mediation has failed and the matter will go back to court. So question of orders being passed in mediation cannot arise, and the question of party disowning the order or non-complying with the order also cannot arise. In mediation, the mediator also is required to sign the agreement. Is it compulsory to produce the evidence document, or oral evidence is also accepted in mediation? You are not bound by the Indian Evidence Act in mediation. There is no requirement to have any documentary evidence or oral evidence. The moment there is a discussion wherein parties have accepted that this is how they wish the dispute to be resolved, it is only the consent of the parties along with their acceptance and agreement of the terms and conditions that is required. You do not require any documentation. But of course, if, for example, there is a matter in which you have certain post-dated checks that one party has offered to the other party, consent terms have been arrived at. So those documents will then be part of the record of the mediation report, which will then be sent to court. There is no strict and stringent procedure to determine mediation through the Indian Evidence Act or the Code of Civil Procedure. In fact, the new Mediation Act exclusively bars the Code of Civil Procedure and Indian Evidence Act to be adopted and utilized for mediation. Next is, in how many days or sessions should the dispute be resolved? Is there any timeline for completion of mediation? The new Act provides for 120 days, extended by another 30 days. So 150 days it has to be resolved. If it can't be resolved in 150 days, of course, mediation has been ineffective. The matter will go back to court. Next is, who shall pay for mediator and what proportion would that be shared between the parties? You are the master of your agreement. You have the power to decide who is going to pay for it. If you have not decided in your clause, in your dispute resolution clause, then both parties are called upon to pay half the mediator fee. Of course, if the defaulting party does not pay it, then the claimant party will then be burdened to effect the payment of the defaulting party. And eventually it will be settled in terms of costs and damages whenever awarded. Last 2-3 questions only, Agarwal ji. I think everyone's question should be answered.
You have already given the answer for that. So,
last is, can a member of ICSI be eligible to act as a mediator? Agarwal ji, I think you have already answered that, but if you could just elaborate that on a little,
yes.
more.
So, Gaurav sir, thank you. Now it's time for the vote of thanks. So, Shri Gaurav Sharma sir, it is my privilege to have been asked to propose vote of thanks on this occasion. I, on the behalf of President ICSI, extend a very hearty vote of thanks to you for gracing this occasion and sharing your valuable knowledge with us. Sir, we are all inspired by your valuable insight on mediation. Thank you very much, sir.
Thank you so much, Agarwal ji, for this opportunity. I really hope that, I could express myself and all the participants could appreciate, our discussion today. And hopefully from today onwards, they could, keep their mind a little bit more open towards resolving disputes through mediation. I think that will be an achievement for us all. Thank you so much. It was an absolute pleasure.